Thorne Whitfield did not raise his voice when he said it. That was the part Camille kept coming back to afterward. He did not yell. He did not throw anything. He simply set down his coffee cup on the kitchen counter, looked at her the way a man looks at a spreadsheet that no longer balances, and told her she had 60 days to vacate the house. "I've spoken to my attorney," he said. "The paperwork is already drafted." Camille Ashby Whitfield, 36-year-old director of community lending at Whitfield Capital Group and wife of Thorne Whitfield for 11 years, stood in her own kitchen in bare feet with a dish towel in her hands, and she did not say a word, not because she had nothing to say, but because somewhere in the back of her mind, a door had just opened, and what was behind it was so large and so cold that it took the breath straight out of her chest. She had known something was wrong for months. The late calls. The weekend trips to Atlanta he described as due diligence. The way Thorne had started locking his phone screen before setting it face down on the nightstand, a new habit, small enough to explain away. She had told herself it was stress. She had told herself it was the merger. She had told herself a lot of things, the way a person does, when the truth is sitting right in front of them and they are not ready to pick it up yet. But she had not expected this. Not the attorney. Not the 60 days. Not the coffee cup set down so gently, like none of it cost him anything at all. Thorne was 44, the chief executive officer of Whitfield Capital Group, a private real estate holding company his grandfather had founded in Savannah, Georgia, in 1962. The company had expanded under his father and then under Thorne until it controlled a portfolio valued at somewhere above $3 billion. A number most people in their social circle said with a kind of reverence, the way you say a number you have never personally touched. Thorne had grown up knowing what the company was worth. He had grown up knowing what everything was worth, including people, including Camille. She had met him at a charity gala in Charleston 12 years before. She had been working as a financial analyst then, new enough to the industry that she still felt the distance between herself and rooms like that one. The kind of room where the flowers cost more than her monthly rent, and nobody mentioned it. Thorne had walked over to her because she was standing near the bar, and he wanted a drink. They had ended up talking until the event staff began stacking chairs around them. 6 months later, he proposed. 8 months after that, she moved into his house in Savannah. She told herself later that she had loved him. She believed it, mostly. But she also knew, the way women who are honest with themselves know things, that marrying Thorne Whitfield had felt at the time like being chosen, like being recognized, like a door opening in a direction she had not thought to look. She had given the marriage everything she had. She had given up her position at the firm in Charleston and joined Whitfield Capital's community lending division, the arm of the company that nobody on the board talked about at parties. The part that lent money to small developers in underserved neighborhoods, that funded affordable housing projects and community land trusts and small business corridors in places the private equity world called emerging markets, and then mostly forgot about. Camille had built that division from a departmental footnote into the most consistently profitable and publicly praised arm of the company. She had done it quietly, the way she did most things, without making it about herself. Thorne had never once mentioned it in an earnings call. After he left the kitchen that morning, Camille sat down on the tile floor with her back against the cabinet and the dish towel still in her hands. She sat there for a long time. She was not crying, she was thinking. The company was registered to Whitfield Capital Group, Inc. The board was made up of 7 members, 6 of whom Thorne had appointed himself. The 7th seat, the founding trustee seat, the one his grandfather had written into the original Articles of Incorporation as a permanent check on executive authority, had been held by Thorne's grandmother, Dorothea Whitfield, until her death 4 years ago. After Dorothea died, Thorne had left the seat vacant. He had explained to the board that the founding trustee seat would need to be restructured, that the legal language was outdated, that his attorneys were reviewing the corporate charter. That review, as far as Camille knew, had never concluded. She got up from the floor, folded the dish towel, and placed it on the counter exactly where she had found it. Then she went upstairs to her home office and closed the door. She had not thought about the trust in years. Not since the winter before Dorothea died, when the old woman had called Camille into her sitting room at the family estate on Tybee Island and poured her a glass of sweet tea and talked for 2 hours about the company her husband had built. Dorothea had been 82 then, still sharp in the way certain old Southern women are sharp, not loud about it, but present in a way that made you feel she was reading something in you that you hadn't finished writing yet. At the end of that conversation, Dorothea had pressed a small envelope into Camille's hand. "You keep this somewhere he won't look," she said, not unkindly, just matter of fact, the way a woman says something she has been thinking about for a long time. Camille had tucked the envelope into a fireproof box in the back of her closet, behind 2 years of tax returns and her college diplomas, and she had not opened it since. She opened it now. Inside was a single folded document, 6 pages, printed on the kind of heavyweight paper that corporate attorneys use when they want you to understand that a thing is serious. At the top of the first page, in a typeface she recognized from years of reading legal filings, was the name, the Whitfield Founding Trust, Third Amendment and Restatement. She read it once quickly. Then she made herself slow down and read it again. The founding trustee seat, it turned out, had not been left undefined. Dorothea Whitfield had amended the trust 3 months before her death. The amendment named a successor to the founding trustee position. That successor, by the terms of Dorothea's amendment, held veto authority over any change to the corporate charter, any sale of core assets exceeding $50 million, and, here was the sentence Camille read 3 times without moving, any involuntary removal or constructive dismissal of an officer or director with more than 5 consecutive years of service to the company. The successor named in the trust was Camille Ashby Whitfield. She set the document down on her desk and looked at the window. Outside, the Spanish moss on the live oaks along the driveway moved slowly in the coastal wind. The street was quiet. A neighbor walked a dog past the iron gate at the end of the property. Camille picked up her phone and called the one person she trusted completely, which was her older brother, Sutton Ashby, 41, a tax attorney in Columbia, South Carolina, who had never once in his adult life given her advice she regretted taking. "I need you to come to Savannah," she said when he answered. He could tell from her voice that it was not a social call. "When?" he said. "Now," she said. "And bring whoever you trust most on corporate law." Sutton arrived the next afternoon with a colleague named Pratt Kimball, a quiet, precise man in his 50s who specialized in fiduciary governance and who, within 45 minutes of reading Dorothea's amendment, looked up from the document and said, with the particular restraint of someone trying not to alarm anyone unnecessarily, "This is an extraordinarily powerful instrument." "Is it valid?" Sutton asked. Pratt considered the question for a moment. "It was properly executed and witnessed. It was filed with the probate court in Chatham County at the time of Dorothea's death. Whether Thorne's legal team knows it exists is a separate question. But as of right now, yes, it is valid." Camille sat across from both of them with her hands folded on the desk. "What does it mean?" she said. "In practical terms." Pratt set the document down. "It means that Thorne cannot restructure the founding trustee seat without your approval. It means he cannot amend the corporate charter, cannot sell any major asset, and cannot remove you from your position at the company, not without triggering a provision that would require full board disclosure and a 90-day review period." He paused. "It also means that as founding trustee, you have the right to call a full audit of all financial records for the past 5 years. The room was quiet for a moment. "And if the audit found something?" Sutton said carefully. Pratt straightened his pen on the table. "Then the founding trustee would have the authority to recommend action to the board." Camille did not say anything, but she had been the director of community lending for 9 years. She had spent 9 years reading Whitfield Capital's financial reports, and she had noticed, over the past 18 months, certain things she had told herself were above her pay grade. Vendor payments that ran through subsidiaries she had never heard of. Executive expense allocations that appeared in one quarter and vanished in the next. A line in the most recent annual report that categorized $12 million as strategic development reserve with no attached project description. She had told herself it was not her business. She was starting to reconsider that position. Over the next 3 weeks, Camille did not move out of the house. She did not hire a divorce attorney. She responded to Thorne's attorney's communications with brief, polite acknowledgments that committed to nothing. She went to work every day, sat in her office at Whitfield Capital, attended the meetings she was invited to, and said very little. And every evening, after Thorne had gone to bed, she sat at her desk in the home office with the door locked and worked. She was careful. She only accessed records she had legitimate authority to view in her role as a director. She documented everything. Every number that didn't align, every payment without a corresponding project file, every vendor name that appeared in the system without a contract attached. She saved nothing on the company's servers. Everything went to an encrypted external drive that she kept in her car. It took her 11 days to find the center of it. The payments were running through a development subsidiary called Heron Bay Holdings, LLC, a company registered in Delaware that appeared nowhere in Whitfield Capital's publicly filed disclosures. Heron Bay had received, over the past 4 years, a total of $23 million in transfers from Whitfield Capital's operating accounts, classified in each case as intercompany loans. There were no repayment records. There were no loan agreements. There was not a single document in the system that established what Heron Bay Holdings actually did or who owned it. She searched the Delaware Secretary of State's business registry. Heron Bay Holdings, LLC, registered member and sole owner, Sylvie Crane. Camille sat very still for a moment. She knew that name. Sylvie Crane, 33, was Thorne's director of acquisitions, the woman who had joined the company 2 years ago with a resume that described experience at 3 private equity firms, all of which, Camille now noticed for the first time, had no searchable web presence. Sylvie occupied an office 3 doors down from Thorne's on the executive floor. She traveled with him frequently. She was, according to the company's internal directory, responsible for identifying and evaluating strategic acquisition targets in the Southeast Corridor. According to the Delaware Registry, she was also the sole owner of a company that had received $23 million from Whitfield Capital, with no documentation and no repayment. Camille made a copy of everything, put it on the external drive, and sat back in her chair in the dark office. She thought about Dorothea Whitfield, pouring sweet tea in a sitting room on Tybee Island. She thought about the way the old woman had pressed the envelope into her hands with the calm certainty of someone completing a task they had been preparing for a long time. She thought about Thorne setting his coffee cup down on the counter like it didn't cost him anything. She picked up her phone and called Pratt Kimball. "I'm ready," she said. The board meeting was called for a Tuesday. Pratt filed the formal notice on behalf of the founding trustee, which was Camille's first public exercise of the authority Dorothea had left her. Under the corporate charter, a founding trustee notice of special meeting required the board to convene within 10 business days. No member could waive attendance. The agenda item was listed as required in plain language. Review of financial irregularities, Heron Bay Holdings, LLC. Thorne found out about the meeting the same morning the notice went to the board. Camille was in her office at the company when he came through the door. He did not knock. He closed the door behind him and stood in front of her desk with a look on his face that she had never seen there before. Not anger exactly, but something underneath anger, the thing that lives in a person when they realize the map they were using is wrong. "What is this?" he said. "Not a question. It's a board notice," Camille said. "I'm exercising my rights as founding trustee." "You can't." He stopped. Restarted. "That trust document is being contested. My attorneys filed nothing with the probate court," she said. "I checked this morning. As of today, the amendment stands." He looked at her for a long moment. Something shifted in his face. "Camille," he said, and his voice had changed. Softer now, the voice he used when he wanted her to understand that things could be handled quietly between them, that there was no need to make something into a situation. "Whatever you think you found, this can be worked out privately. You don't need to do this in front of the board." "I know," she said, "but I'm going to." He left without saying anything else. The board meeting lasted 4 hours. Pratt presented the findings methodically: the transfers to Heron Bay Holdings, the absence of documentation, the Delaware registration, the beneficial ownership. When the slide appeared on the screen showing Sylvie Crane as the sole member, 2 board members asked to take a recess. One of them stepped into the hallway and did not come back for 20 minutes. Sylvie Crane had not been invited to the meeting. She resigned by email the morning the notice was filed, before anyone had told her what the notice contained. That was the detail that stayed with Camille afterward. The resignation that came too fast, from someone who had clearly been watching for exactly this kind of signal. Thorne sat at the far end of the conference table throughout the presentation. He did not speak during the evidentiary portion. His attorney leaned over and said things to him that Camille could not hear. At one point, Thorne looked down the length of the table at her, and she held his gaze until he looked away. The board voted at the end of the meeting to commission an independent forensic audit, to freeze all transfers to and from Heron Bay Holdings pending investigation, and to refer the matter to outside counsel for a determination of legal exposure. 5 of the 6 board members Thorne had appointed voted in favor. The 6th abstained. The founding trustee vote was not required to carry the motion, but Camille cast it anyway, in favor. The divorce proceedings, which Thorne had initiated as a formality he expected to control, became considerably more complicated after the board meeting. His attorney called Sutton twice in the first week. Sutton did not return the calls. Pratt, in the meantime, had identified that under the corporate charter as currently written, the founding trustee's seat carried a spousal continuity clause, a provision Dorothea's original attorneys had inserted in 1985, apparently in response to a different family dispute which Pratt described simply as ahead of its time. The clause specified that a founding trustee could not be removed or replaced by any action related to the dissolution of a marriage without the consent of the full board. Full board consent required 7 votes. Thorne controlled 6. The The forensic audit ran for 9 weeks. What it found when it came back was more than $23 million in improper transfers. It also found a pattern of inflated vendor invoices over a 3-year period, expense account activity that exceeded documented business purposes by roughly $800,000, and a set of intercompany loans to 2 other subsidiaries that had not been disclosed to the board. Total unauthorized movement of funds, $41 million approximately. The financial press in Savannah ran a brief item. The Atlanta business journals ran a longer one. Thorne's attorney issued a statement saying his client was cooperating with all inquiries and that the audit findings were subject to multiple interpretations. Thorne moved out of the house on a Thursday in November without fanfare, with 2 large suitcases and a look on his face like a man who was still working out how this had happened. Camille stood in the doorway and watched the car go down the driveway and through the iron gate, past the live oaks with the Spanish moss, moving in the coastal wind, and out onto the street. She had not planned what she felt in that moment. She had expected something that felt more like triumph, or at least relief. What she actually felt was quieter than that, a kind of settling, like a long-held breath finally released, like the world rearranging itself into a shape that had always been waiting for her to let it. The Community Lending Division of Whitfield Capital held its annual report presentation 3 months later. Camille presented the numbers herself to the full board. Loan repayment rates 89%. New affordable housing units brought to completion in the fiscal year, over 400. Community development grants administered through the division's non-profit arm, $2.4 million. Return on invested capital for the division over the 9-year period of her directorship, consistently above the company's overall portfolio average. One of the board members, a retired developer from Augusta named Bridwell Crane, no relation to Sylvie, leaned back in his chair after she finished and said, "You built this." It was not a question. "Yes," Camille said. "On your own," he said. She considered the question honestly. "With a good team," she said. "But yes." Bridwell Crane nodded slowly. Then he said something that nobody in that conference room had said to her in 11 years of showing up and doing the work. "We should have been saying that out loud a long time ago." The board voted in that same meeting to name Camille Ashby Whitfield as interim chief executive officer pending the completion of executive transition procedures. The motion passed 7-0. She drove home through Savannah in the early evening, through the squares with the fountains and the magnolias, and the old carriage houses turned into law offices and boutiques. And she thought about Dorothea Whitfield pressing an envelope into her hands in a room on Tybee Island and saying, in a voice that had held no particular drama, "You keep this somewhere he won't look." Dorothea had known. Camille understood now. She had seen what Thorne was, perhaps long before Thorne had fully become it. She had watched Camille, and she had made a decision in the quiet way that certain old women make decisions, without announcement, without argument, without any need to explain themselves to people who would not have understood. She had simply handed Camille the door, and she had trusted her to know when to open it. There was a specific kind of woman, Camille had learned, that other people in rooms like those board meetings tended to underestimate. Not the loud ones, not the ones who announced themselves. The ones who arrived early and stayed late and built things that outlasted the people who ignored them. The ones who folded their dish towels and put them back where they found them and then went upstairs and closed the door and did the work. Thorne had spent 11 years watching Camille be that kind of woman without once registering what it meant. She parked in the driveway under the live oaks. The house was quiet. The gate at the end of the property stood open, as it always had, as if it had never had anything to keep out. She went inside, put on water for tea and sat down at the kitchen counter. The same counter where Thorne had set down his coffee cup 7 months ago, in a room where he believed he was the only person who knew how the story ended. She picked up her phone and called Sutton. "It passed," she said when he answered. He was quiet for a moment. Then he made a sound that was not quite a laugh and not quite anything else, but that she had been hearing from him her whole life, the sound he made when something turned out the way it should have all along. 7-0, she said. "Good," he said. "Just that. Good." She hung up the phone and sat in the kitchen for a while with her tea, listening to the house settle around her. Outside, the Spanish moss moved in the evening wind. The street was exactly as quiet as it had always been. She had not needed to raise her voice. She had not needed to threaten, or perform, or make anything louder than it already was. She had simply done what Dorothea Whitfield had trusted her to do. She had kept the envelope safe. She had waited until she understood what she was holding, and then, when the time came, she had opened it.